Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friend Omar Serrato, the Tilted Lawyer. He's going to be back in 30 seconds. We were trying to fix something right before we started, and then as we were doing that, a new filing came in on the docket. Don't worry, it is only a 4-page letter, so we don't have to worry too much. And yes, I will read it tonight. I don't know if we're going to read it first or if we're going to read it after, but Omar and I are going to go through Blake Lively's 21-page filing from earlier. He's going to give us some legal takes, and then we will take a look at that letter. Now, remember, yesterday, Justin Baldoni's side had filed a letter saying basically that Blake Lively and Leslie Sloan's teams will not allow for an extension of time for all parties, even though it would be like a reasonable professional courtesy. And so this letter that just came in, I haven't read it yet. I just saw that it's 4 pages. This letter that just came in is going to be their response to that as to why they don't think the parties should have an extension of time. So we can ask Omar about that too when he gets back. He's pouring himself a drink right now. I would too if I had a stream with me for God knows how long. So it's not gonna be that long, guys. Don't worry. So we'll just wait for him to get back before we start. I'm gonna post this letter also on Twitter real quick. I don't know what's going on over there. Hopefully he's not falling over or anything like that. But if you were here earlier and you came back tonight, thank you very much for being here. I appreciate you. Right. Copy link to that.
Are we live?
Yeah.
Oh, well.
Yeah.
How are you, Lauren Neidigh?
I was just waiting for you to get back.
Young lady. Well, shit, I know I told you to start. I just didn't think you would. But now I know.
What else would I be doing, man? I don't know if my microphone is working over here, if it's the laptop one. Let me check real quick. Oh, we're good. We're good. Okay. Ooh. Can you make sure commercials are turned off for the live?
That's up to Lauren. I think
I can make them less frequent, but I put them on a lower setting.
Yeah.
But guys, you're asking the creator to like turn off their revenue is a little, like
the best way to do that though is to like if excessive super chats will mean like
I'll just turn them to a lower setting for now. Hang on.
Yeah.
Especially because, dude, this shit is not cheap. Like I got my, Pacer bills quarterly or whatever.
Bro, I got mine.
Yeah, I got mine last night, and I was like, "Oh my god!"
It's like, what did I spend $100 on? I was like, "What is this shit?" I was
like, $100 is like a fraction of mine. I'm not even kidding. Like it's bad.
How much is yours? Jesus.
Oh, I'm not gonna answer that question.
Well, mine was $100. I was looking at. I was mad at my assistants. Like, what did we spend $100 on? It's like, oh shit, yeah, the Lively thing. Anger is misplaced.
We're gonna have to start like a community fund or something. Anyways, we'll deal with that later. But I set the ads to go like at half speed or whatever, half frequency that they were. So okay. Let's see. What do we want to go through first? So this 4-page letter just came out, and then also
let's do the letter first. I haven't looked at any of this.
Okay.
I've been home for like an hour.
All right.
I had dinner with the family. Everyone's in bed, and so I literally don't know what I'm stepping into. But I did skim through Lively's her attempt to bury Wayfarer with her response. It was pretty ugly. Yeah. I haven't highlighted it or anything, but I skimmed it. It's pretty bad.
Yeah.
Rayana says, feel free to show your thoughts. To show my thoughts.
Please don't show me your thoughts.
That's not a good idea.
Community violation. Hello.
Lauren, 5 minutes later, hey, Omar, my face is on your thing. It's like, what?
All right. Let's see.
Oh, boy.
And this is from... Can you read that okay? Like the letters are big enough?
Oh, do you want me to read them?
No, I was just wondering if you are able to see that.
Oh, I can see you. I
Okay,
got the big screen up here.
Okay.
Because I'm not 34,
I'm 32, bro. Jesus Christ. For the last time. Okay. Dear Judge, Blake Lively and Ryan Reynolds...
32. By the way, did you know that 32 is my favorite number?
No? Why would I know that?
Because it was my favorite number when I was a ball player. It was my number when I played ball. back when I was an athlete. But now I'm just a...
Mine was 23, actually.
Of course it would be the opposite of mine.
Yeah. All right. Blake Lively and Ryan Reynolds respectfully submit this letter in opposition to the Wayfarer party's motion to extend the April 18th deadline to move to amend or join additional parties, and for an extension of time to respond to outstanding interrogatories. Now, I'm assuming you saw...
This is the discovery stuff, yeah.
Yeah, you saw that the other day.
So can I just preface this?
1,600, is that... Yeah, go ahead.
It's way excessive. It's way excessive. But it's really odd when you have these discovery battles. If somebody asks me for an extension for discovery, yeah, whatever. How long do you need? That's my question. How long do you need? If they tell me 30 days, I say, make it 45. Let's just get them done. Mm-hmm. And that's how you build goodwill with opposing counsel. Because this is our career. It's our livelihoods. It's not life or death, man. You got to be respectful to your colleagues. Because you got to work with these people for years and years. You learn that really quickly that, hey, it's not just a one-off. You're going to keep working with these lawyers for years to come. And so if you don't want them to be a dick to you, you don't be a dick to them. But they're like, oh no, 1,600 requests for production of documents and 171 interrogatories across 31 sets. And they had 30 days to do it, and they've been answering. They've already answered 500 of them. And they just asked for a reasonable 30-day extension. So here's what happens. If you don't comply with the responses in time, you can still answer them, but the ramifications are if there are objectionable interrogatories or special interrogatories or requests, objectionable discovery requests. If you don't respond in time, you waive your objection. I guarantee you, in the course of 171 interrogatories and 1,600 requests for production of documents, there are objectionable ones. So they can't just let the deadline slide. And so they ask them for 30 days, say, we'll give you 30 days for our stuff. And they say, no, fuck off. Fuck you. It's basically what they said with no kind of explanation, no kind of whatever. And so now I guess this is their response. They're just being really reasonable. And then the other request was what? They wanted an extension on the deadline to file a motion to amend their complaint. They said, look, we have 4 pending motions to dismiss. We've already said that if the judge wants us, we will voluntarily move to amend our petitions. So rather than go through this redundancy of I'm going to file a motion when I have the judge's decisions pending, where he's going to give us direction as to what he wants to see, let's just extend this deadline to 21 days after he makes his final decision on the last motion to dismiss, and then go from there. And they're like, no, fuck you. It's literally what they said. But what they actually said was, no, because that deadline is not tied to the motions, and so no, just completely illogical. New York Times was cool with it.
People are asking if your mic is patched in, like your mic, not your laptop mic or your computer mic.
I don't know.
You sound.
How do I sound to you?
You sound far.
Do I still? Well, you know what?
People came here for your voice, Omar. Just let them have it. Yeah, no.
He'll get a message brought to you by the Church of Jesus Christ, Latter-day Saints.
Jesus is not in the room with us right now, sir.
My mic is on. I'm not sure. Does it sound echoey? How do I sound in your?
Well, you have to change your mic sometimes because your thing is.
All right, I'll tell you what. I'm going to pause for 30 seconds and come back and see if that fixes anything.
That's fine.
All right.
I mean, we can hear him. It's just he doesn't sound as loud as usual. Okay. So, where do we get to here? The motion to amend the court scheduling order should be denied. The Wayfarer parties seek to amend the court's case management plan and scheduling order of February 3rd, entered at the joint request of the parties, by extending the time to amend pleadings from April 18th to a date 21 days after the court's last issued ruling on the pending dismissal motions. As the court is aware, the court's model case management plan and scheduling order requires that absent exceptional circumstances, the deadline to seek leave to amend the pleadings be fixed at a date not more than 30 days following the initial pretrial conference, which would have been March 5th in this case. Okay. At the time they proposed the April 18th deadline, the parties explained that a departure from the outer limit was warranted to avoid unnecessary additional requests for extension of the schedule, because after conferring one or more of the parties anticipated amending their complaints and or joining additional parties. The very next day, the Wayfarer parties filed their amended complaint before any responsive pleading or pre-answer motion had been filed. Why does that matter?
I didn't hear what you just said. Does my mic sound any better?
No, you sound about the same, but I mean, we can hear you. It's okay.
All right. Well,
it's just not your good mic's not working. Did you go to settings on StreamYard and audio?
I did. Yeah. It's on the right one. It is on the right one.
You sound okay to me, but maybe just turn your mic volume up or something.
Is it just that one person, or is it a?
No. It's a bunch of people.
Oh, it's a bunch? Well, fuck.
Yeah.
I don't mean to curse, but you know.
You don't need to censor yourself here. It's fine.
All right. I'm going to try one more thing. I'm going to start and restart my Rodecaster. And if that doesn't fix it, we're just going to roll with it.
All right. Sounds good.
All right.
Okay. At the time they proposed the deadline, the parties explained that a departure was warranted to avoid unnecessary requests. Okay, we read that part. The very next day, the Wayfarer parties filed their amended complaint before any responsive pleading or pre-answer motion had been filed. As counsel for Ms. Lively and Mr. Reynolds noted at the initial pretrial conference, the Wayfarer party's maneuver was executed without notice to any other party and seemingly without any reason, given the parties had conferred and agreed to an extension of the default deadline for amendments in the scheduling order. Okay. Nonetheless, at the same February 3rd conference, counsel for the Wayfarer parties represented that first and foremost, we would like to move the case along as quickly as possible and think that the order that we had agreed to works notwithstanding the amendment of the complaint. Wait, notwithstanding the amendment of the complaint. So isn't that kind of contradictory what they said there? I'm confused. We'll wait till we get to that. Sound? I think that's better. Yeah.
All right. I think it was a StreamYard messing with my settings.
I had problems with that too. A bit ago. But
yeah, I think I'm good now. We'll see.
Okay, cool. All right. Well, so they're saying here that at the scheduling conference back on February 3rd, they had moved the deadline to April 15th, or proposed the April 18th, deadline. And now they're saying basically that they don't want them to move it again, is like what I'm getting here.
Yeah, well, we have new information. Back then, there wasn't 4 pending 12B6 motions.
Yeah,
and 12B6 motions are
100 requests. Yeah.
Yeah, look, it's just a matter of like, why are we wasting time with motions to amend? They're already at issue with these 12B6. And furthermore, the judge is going to make a decision and determine the direction he wants the pleadings to go. He's going to determine the sufficiency of the pleadings. And so we can voluntarily amend, but they're already at issue with these 12B6. Let the judge rule, give us direction as to how he wants them amended, and then we'll go. And so, because that deadline is essentially, if you want to amend, you got to get your motion in before the 18th. Why would we do that? There's no chance Judge Lyman is going to have all of this wrapped up by the 18th. So let's just extend it to 21 days after the final 12B6. They're trying to avoid unnecessary motions, unnecessary hearings. And really, that goes for everybody across the board. It's just such a nonsensical thing to not agree to. Like, even their reasoning here is stupid. I would be so pissed at them if I was counsel on the other side.
So also, is this going to look bad that they keep doing this? Because they also refused to give an extension when Brian Friedman's house burned down in the California fires. Yeah, no, this is a pattern for them. It is a pattern. Excessive. What do we have? We have excessive discovery, unreasonableness back when people's houses were burning down, unreasonableness at the face of these 12B6 motions, and a very simple, reasonable request to extend that benefits everybody. No reason given. First of all, there's a rule. You can only give so much discovery. You can't give unreasonable amounts. Like, for example, you're only allowed to give 35 special interrogatories. If you go above that, you better have a good reason. You got to write it in, and then the judge could approve it. They could disapprove it. They could file a protective motion to whittle down your discovery. Like, the point of discovery is not to bury people in paperwork. You're supposed to know what you're looking for and look for those things. One of the things that Friedman said in his letter was, okay, I got 1,600 RFPDs and 171 interrogatories across 31 sets. What are we doing?
Not only is this excessive and unnecessary, but we've asked for, and we haven't even objected. We've already responded to 500 of them. We're in the process of doing it. We're not going to finish the remaining 1,100 in 8 days. How about a 30-day extension? And we'll give it to you as well. And it's like, no. That's it. Just no. Just no. For no good reason. It's like it's infuriating.
Yeah, it's so this is, I guess, Sloan did not even give a reason, and Sloan hasn't written a letter. The judge said like a letter responses are due at 4 p.m. tomorrow, so I don't know if she'll write one or not. But basically, Sloan was just like no, and then they didn't even explain themselves.
Yeah, so, well, they're on the same side, and so it's pretty obvious to the judge what's going on. If I was a judge, I would be pissed.
Yeah,
like it seems pretty reasonable. They want my direction. Why waste time filing a voluntary motion when they've already clearly cited that they're willing to do it? The benefits seem obvious. We'll have direction after my decisions on the motions to dismiss. I may or may not ask them to amend the complaints. So what's the harm in extending it 21 days to a much more reasonable date? I don't want to come here for multiple hearings on this stupid shit. Why don't you all just get your ducks in a row? We'll come back when you guys are ready. That's kind of what Lyman, I'd imagine, would be thinking. As an attorney, I'm like, it's making my blood boil how unreasonable they're being. But it's also to me a crack in their armor a little bit, that they know they're getting their ass kicked in the public in these complaints. They know they have the losing argument on like 90% of the law. They have unreasonable clients. They're sick and tired of getting, destroyed. They have very little control over anything. And so they're asserting it where they have it, which is, no, I'm not going to voluntarily grant your request for an extension. The hell out of here. Write a letter. You know what? Why don't you go tell me then? Write a letter to the judge. It's basically what they said. And here we are. And here's their reply. So with that context, let us continue.
All right. Scheduling order may be modified only for good cause with the judge's consent. Okay, well, I feel like we have that. Accordingly, 3A requires that any motion to amend the scheduling order shall be accompanied by a letter identifying with particularity why good cause exists for such amendment. They literally did that yesterday. What are you talking about?
No.
That requirement applies with equal force to the scheduling order's deadline for a motion to seek leave to amend the pleadings. Indeed, Rule 16b requires that the court set such a deadline to offer a measure of certainty in pretrial proceedings, ensuring that at some point both parties in the pleadings will be closed. Whoa, bro. What's going on over there?
They consulted ChatGPT and asked them to give them some law on this, and this is what they had to copy and pasted.
No, I meant with you. That was it sounded like you were sniffling or something.
My mic is doing, like my buttons are, I don't know. My roadcaster's all effed up.
Oh, well. That's fine. Okay.
So you didn't even hear that, huh?
No, we're good.
All right. See? See what happens? All right. Let us continue.
The Wayfarer parties do not even mention the good cause standard, much less identify with particularity why it is satisfied here, nor could they. The scheduling order has been in place since February 3rd, and they have known since February 11th that the Lively Reynolds party's response to the amended complaint was not due until March 20th. Rather than wait for motions to dismiss to be filed, the Wayfarer parties inexplicably used their sole opportunity to amend as of right on January 31st, knowing full well that further amendment would require leave of court. In other words, the predicament in which the Wayfarer parties now find themselves, wishing that they had drafted their amended complaint differently, given arguments raised in the motions to dismiss, is the result of their strategic decision to file an early amendment. So are they still mad about that? I mean, damn.
Yeah, anyone would also argue that it was in good faith that they did that. But it is a move to do your first amendment voluntarily without a reason to do so. But here we are. But they also re-raised the issue. So they voluntarily did it. And then they bring a 12b6. And they're in the middle of discovery. And a lot of the reasons why they would dismiss the complaint are discovery issues. And so I see their point logistically. But the way that this case is played out, it makes a lot of sense why you would grant them that extension.
Yeah.
And I would look at two things. I would look at the excessive amount of discovery. What reason do we have for 1,600 requests for productions of documents. You got to admit, you got to imagine there's going to be some objections coming, that these requests are meant to annoy and harass, to oppress the other party, to intimidate them into a settlement that they have no desire of entering into. There's a lot of objections to that, to excessive discovery. And so we don't know how this is going to play out, but there's a lot of reasons why you would, in light of the excessive discovery request, ask for extensions. So they're acting like Wayfarer didn't have their shit together, but really nobody asked them to write 4 12B6 motions to dismiss their complaints. They did that. Nobody asked them to have this excessive amount of discovery that they themselves have not received. So to put it plainly, they're litigating like a couple of bitches.
Jesus. All right.
How about that?
I mean, it sounds about right to me, but I had to hear you say it because you're the attorney.
I would be pissed. I was like, this is what we're doing. Okay. All right. I got something for you. Look, there's 2 ways that I litigate. One is like, I'm cool as fuck. What do you mean? I'll give it to you. You want extensions? I'll give you extensions. Because I'd rather just get to the bottom of it. But if you're going to come at me like that, I got that in my playbook too. You're not going to like it when I do it. And I'm going to do it better than you. I mean, that's my ego speaking. I don't know. These guys would kick my ass probably. I'm just saying. There's ways that attorneys navigate around each other. If you're cool with them, generally they'll be cool with you. If you want to turn it into World War III, we could go that route. And the law provides ample ammunition. We don't have to look very far. So there's that.
Yeah. Okay. So let's see. Indeed, they previously sought a modification of the briefing and amendment schedule on February 26th. Let's see. At that time, seeking to file all of their oppositions to all motions to dismiss and or amended complaint 2 weeks after the last motion was filed, or April 3rd, whichever was later, which all of the defendants declined at that time. Yet the Wayfarer parties took no action until now, even though their current issues with the schedule were both foreseeable and their fault. And they're citing Furry Puppet Studio here. It's the case they're citing is Furry Puppet Studio versus Fallout Boy. I forgot to read that on the first page. All right.
Furry Puppet, what is this, like Muppet Babies?
I guess so, man. The premise of the Wayfarer party's request that they should be entitled to read the court's decision on the motions to dismiss before seeking leave to amend is unsupported. Rule 15.
They're not arguing entitlement, though. Look, they're not arguing entitlement.
Yeah.
They're not saying we're entitled to anything. We're saying the circumstances warrant an extension here for both parties, and an extension is not going to prejudice either side. It's not about entitlements. You guys put this shit on us. So, look, we will comply if we have to, but we're just letting it be known that you put us in this position, and you're being difficult for no reason because you have a losing case and everybody knows it. So don't try to take it out on us. We're just doing our jobs. Maybe if you all knew the law better, maybe if you all knew what constituted actual sexual harassment, we wouldn't be in this position. Maybe if you actually put together a modicum of a plan for how a conspiracy for a smear campaign was lodged against your client, we wouldn't be in this position. And yet here we are. So, look, there's a lot of things that could be said, and it's coming out in full force in these letters. And I think that's like 80% of what makes this case interesting is that the lawyers effing hate each other.
Yeah.
And they're not even like all that far apart skill-wise. I just think that Lively's attorneys have a tougher case. It's not like they're not good attorneys. They know how to litigate at a high level. They just have the clients who they have. They got the case that they have, and it's starting to weigh on them. They've been dealing with this now since December. They probably got really difficult clients that are expecting results. They're feeling it right now. Their nerves are shot. Their anxiety is through the roof. They probably could do with like a couple of days off. Maybe a full weekend would be nice. They got paralegals running around trying to find angles to the law that they keep getting their ass kicked with. And they're not doing very well in the public specter. So all of these things correlate to now they're just, you know what, fuck you and your extensions. Go tell on me then. Write a letter to the judge. And they have. And that's why we're here.
Right. Okay, let's see. We already did that. Finally, the Wayfarer party's assertion that granting this request would not prejudice any party is baseless. To the contrary, the Lively, Reynolds, and Sloan parties would be significantly prejudiced by an unwarranted extension of this litigation in which the Wayfarer...
prejudiced? Explain that to me like I'm 5, bitch. You know what?
In which the Wayfarer parties have not just propounded voluminous and burdensome discovery requests. What? Oh,
I lost my place. Retaliatory. Okay. Oh, voluminous and burdensome. Have not just propounded voluminous and burdensome discovery requests, but continue to advance their retaliatory campaign against Miss Lively and Mr. Reynolds by churning out derogatory content in social and legacy media channels.
In what fucking world?
Nobody. I haven't seen Friedman or anybody churn out anything like that. It's all been YouTubers. No.
What?
Like you and I. And
that's because she's being a bitch. It's not
Dave
because.
Neal and
oh my
who's
God.
that other guy? Podcorn.
Andy. Yeah. Andy.
Yeah, that guy. Mm-hmm. And others.
That guy, Andy. His name was Andy.
I've never been on his show. I've never met him like you have. But I've seen his. I always read his name as Podcorn, not Popcorn. I get confused.
No, dude, it's popcorn, like the food. Like you're watching, you got popcorn, like in it. Like, come on.
The more you know.
Give it the program, bro. All right. Okay. So, and I don't understand this at all because they were just talking about how many requests they put on them, but okay.
Do we know how many they actually propounded on them?
I don't see unless they wrote it here.
No, it doesn't matter.
We'll get to it. Yeah, I know
it wasn't
the other
as extensive as their set.
The other party did 1,600 and like 170.
Okay, but if their number is less than theirs and they're calling it extensive and overly burdensome, they've literally submitted more. So what are we doing?
I don't know, man. This is ridiculous.
They're literally like 3-year-olds.
No party should be asked to endure this continuing harm solely because of the careless litigation decisions made by the Wayfarer parties. Any reasonably diligent party would have been able to meet the court's unusually generous deadline, and the Wayfarer party's request should accordingly be denied. Hold on. This is from the same lady who just got a month extension to drop 802 pages on the judge in Texas, but all right. If this court is inclined to grant any extension of the deadline, the Lively Reynolds parties request that discovery against them from the Wayfarer party's claims be stayed unless and until they are able to settle upon a version of their complaint that can actually survive a motion to dismiss. What does that have to do with your letter? You're just being a cunt to be a cunt at this point. Hey, Brian Friedman didn't tell me to say that. I just saw this for the first time with my own eyes. You're being a cunt.
Among other things.
Oh, go ahead.
The court is inclined to grant. I had to make sure I understand what they're asking for. The Lively Reynolds parties request that discovery against them for the Wayfarer parties' claims be stayed. They want to stay unless and until they're able to settle upon a version of their complaint that can get the fuck out of here because the amended complaint largely depends on discovery. Nobody's staying anything.
Why would you even say something bitchy like that in a letter that's totally unrelated to?
Oh, you don't know lawyers like I do.
No, I don't.
They'll make a whole motion out of anything. They'll make a motion out of chewed gum if you let them. Lawyers are my least favorite people in the world. I want you to know that. I don't envy the fact that I'm a lawyer. I know that I'm a lawyer and I know my profession well. I hate lawyers. I effing hate them. 90% of lawyers, I don't like you. And if I happen to like you, you're one of the good ones. And that's like 9 out of 10. That's not very good odds. And of course, all my opposing counsels, I'm not talking about you. I'm kind of talking about them just a little bit. But they know. But I'm not like that with my opposing counsels, though. My opposing counsels, we all get along. Like we're reasonable. We're literally there just to get to the bottom line of whatever issue we're doing. Very seldom do I have really bad opposing counsel. There's only been one occasion where I've actually almost was ready to fight opposing counsel during a deposition because of how crazy he was getting.
What was it about?
It was about, there was 4 brothers, they owned a house and their sister was suing them for ownership of the house. And we were just going back and forth in litigation and the other attorneys being unnecessarily a dick in the deposition. And he was saying some choice things. And he was an older guy. And back then I would have been what? I would have been about your age probably. And it's listen, guy, we had it out. And then the court reporter had it warn us look, if y'all are going to keep on fighting like this, I will end the deposition. And it's like, well, he's the one. It's like, no, he's the one. It's like, okay. And after that, we kind of became friends after that. And to be honest with you, that's probably one of the best attorneys that I've ever gone up against. I learned a lot from that guy. It's always those ones, man. I just told this to my assistant. Sometimes your enemies make your best friends in life. You start out enemies and you end up friends. They become some of your best friends. I don't know why that is. It's a thing. So
should we get in a fight so I can feel closer to you, or
no? Not at all. Not necessary for you and I.
Okay, well, I'll take your word for it, I guess.
Well, it's just like that thing. You get in a fight at school. Like, what happens? Like, you guys beat the shit out of each other, and then at the end of it, you go to the principal's office, you both get in trouble, and then you hug it out, and then you're best friends.
Yeah, we didn't do that at my school.
Well, I grew up in Gen X, so...
I also just didn't talk to anyone, so there was that. All right. Let's see. I can't believe they wrote that, but all right. The motion to extend the interrogatory response deadline should be denied. Yeah, we heard you. The Wayfarer party's request for a month-long extension for responses to interrogatories due on April 14th rests on a disingenuous attempt to paint the lively Reynolds and Sloan party's discovery request as excessive. How is that disingenuous?
Prove to me that. Look, they haven't filed any motions. They just pointed out that, look, we got 1,600 of these effing things. We're done with 500. We got 8 days to go. We're granting them 30 days. We're asking for 30 days. It's not unreasonable. It's not like we're not doing the work. There's reasons for stuff. And so I don't know. Do you realize we spent half an hour on this 4-page letter that you said was going to be quick?
Well, I can't help how infuriating it is. Let's see. Okay. Although the Wayfarer parties harp on the aggregate volume of requests for production, such requests are irrelevant to the deadline as to interrogatories. They have averaged more outbound requests per party than they have received, but they have a lot more parties.
They're being this argument is moot. They literally offered you a 30-day extension,
right? In
the off chance that it might be a little cumbersome. You guys are the ones that are prompting this argument. And so, look, I'm ready to toss this letter in the trash. It's worth nothing. It tells me everything I need to know about where they feel about their position in the case, and they're on the losing end. That's the way that I'm reading this.
If they take issue with the document request, that is what objections and a meet and confer process are for. The Wayfarer parties are dealing with a modest volume of interrogatories.
They literally try to meet and confer, and you guys said fuck off. What do you mean? They literally went to you guys in good faith and said, I'll give you an extension. Give us one. And they're like, no. But now they're saying, oh, but we could have met and conferred. So you could just say no again? Get the fuck. Oh, my God. I can't, Lauren. You know what?
I just want to see these numbers real quick. Hang on. And then we'll do the rest. If they take issue with the document requests, that is what objections and a meet and confer process are for. The Wayfarer parties are dealing with a modest volume of interrogatory requests designed to guide discovery moving forward. Miss Lively has served an aggregate of 15 interrogatories. Mr. Reynolds has served 36, and the Sloan parties have each served 64 on the Wayfarer parties. On the deadline, the Wayfarer parties will be answering no more than 24 interrogatories served by the 4 parties they chose to sue, 5 counting the New York Times. Had they not wanted to respond to interrogatories from, say, Mr. Reynolds or Miss Sloan, they could... Why are you talking Never mind. They could and should have foregone filing utterly frivolous lawsuits against them or agreed to the Sloan party's request to stay discovery. They're mad because... Sloan's still mad because her request to stay discovery was declined by the judge.
Do you know who they sound like? They sound like Francis. You know who Francis is?
Oh, who the fuck is Francis?
Have you ever watched Pee-wee Herman's Big Adventure?
No, but I've heard of that.
He is the rich kid that wanted to steal Pee-wee Herman's bike. And he hit an indoor swimming pool. And he's like, I know you are, but what am I? I know you are, but what am I? Infinity. You know that whole thing? It's before your time. It came out in 1985. It was very big when I was 5 years old.
Oh my God.
They sound like Francis is all I'm saying.
This is ridiculous. I can't imagine writing this to a judge. I don't know. I just couldn't imagine writing this to a judge.
I wouldn't write it.
Teddy
I would
behind.
have granted the extension. I just totally would have granted the extension.
Oh, man. Okay. Although the Wayfarer parties claim to have been occupied with extensive briefing in the past few weeks, the same holds true for all the other parties who stand ready to provide timely discovery responses. nor is there unforeseeable burden in the written discovery demands being served virtually simultaneously, as the Wayfarer parties have known since early February that all parties would serve initial sets of interrogatories by March 14th. Blah, 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 blah. Okay. The inability of Wayfarer to manage their calendar or the workload that they collectively invited also does not provide a basis for their motion, particularly in the absence of any explanation for why the completed briefing requires a month-long extension. The court should reject the Wayfarer party's invitation to introduce delay into the schedule at the first opportunity. Right away, sir. And instead take them at their repeated insistence that they wish to move forward in discovery without delay. And then the footnote says, despite claiming the parties provided no reason for their refusal to stipulate the extension, the Wayfarer parties omit that there was no discussion when they asked for positions by email. Huh?
I zoned out. I completely zoned out. I'm not listening to the drivel anymore. I've tuned them out. I'd imagine the judge is going to do the same. He's going to get halfway through this and be like, what the fuck is this, man? Give them the effing extension. What are we doing? Oh, the judge has no stake in this fight.
They're citing deadline here from March 21st. Not sure why that's relevant.
Ryan Reynolds, amidst flurry of filings, deadline March 21. Despite claiming that the parties provide... Did you already read that? No. Are we done with this? We're done with this.
Yeah, we're done. That's stupid as fuck, man. Okay. Yeah, so we'll move on to this document, which we only have 14 pages to go through. Oh, let me just make sure real quick.
Considering how quickly we got through these four, we'll be done in a jiffy.
No, because I already read this filing, so I kind of know how to navigate a little bit.
Oh, well, one of us has.
Yeah, okay. Well, you can just keep being the peanut gallery over there. Guys, since it's taking so long, guys, I'm going to read super chats at the end, just so we don't, take up all your time right now. Anyways, let's see. I'll zoom in a little more here. That's probably big enough, right? Lively's response does not attempt to show personal jurisdiction over Wallace or Street because I'm reading the wrong filing. Hang on 1 second. I picked up the wrong thing. 1 sec. Genius. Here it is. My Dropbox is getting a little cluttered with legal stuff.
Oh, did you find something other than Pacer to download documents?
No. Yeah, I do have Court Listener, but I always have them before Court Listener, so I'm like, I'm not waiting for that.
Yeah.
I don't have any patience.
I did know that. You're like, I don't know what is. Whenever something drops, you're just like on it within 30 seconds.
30 seconds. It's more like
there's no refractory time with you.
I wouldn't say no refractory time. I would say little refractory time. All right. Let's see. This sounds more familiar. Yep. The Wayfarer parties have tied themselves in knots trying to state a defamation claim against Miss Lively that is not barred by the statute of limitations or wholly contained within her legal complaints, which they concede cannot form the basis of any actionable claims. They have been entirely unsuccessful. As a result, the Wayfarer parties have hit the do-over button again, reinventing their First Amendment complaints to apply only to alleged statements from July to December 2024 before Miss Lively filed her CRD complaint. If true, then the elaborate tale the Wayfarer parties tell in their 391-plus paragraph First Amendment complaint is largely irrelevant because, according to them, nothing that happened before July 2024, including the production and cut of the film, is part of their defamation case.
That's not my recollection. My recollection is that the stuff goes all the way back to December of 23.
That's what I thought too.
With that 17-point complaint that's been the subject of all of these pleadings. What are they even talking about?
I'm unclear.
All right.
They have essentially admitted that their $400 million lawsuit was a PR stunt. Okay.
They totally did that. Let's just all go home. Let's go home. They're right. They've admitted that, so it's all for PR. Cheers.
He's kidding, everyone. Some people are new here.
I'm totally kidding. Never mind me.
All right, let me. There we go. That's better. The Wayfarer parties do not appear to understand the implications of their own concessions. Remarkably,
can I just say I need to red flag something that I'm already seeing.
You go ahead.
They are using the same language that Friedman was using.
Well, that's what I was thinking.
Was coming out and saying they appear not to understand the law. Now there's a no. They appear not to understand the implications of their stuff, and so they're literally Francis from P.V. Herman.
What if it's like a copy paste job, and then they just replace some words to fit the opposite argument?
I'm not going to get your stuff copyright stricken. Just after the show, Google Francis from P.V. Herman's Playhouse. Playhouse, Big Adventure. You'll see what I mean.
Hey, Shizzy Wisnet, what's going on? Everybody say hi to my friend Shizzy. Thank you for the raid. I appreciate it. All right. Let's see. Are you good? The opposition continues to rely upon allegations they claim are not part of the case. The opposition's discussion on actual malice, for example, is based entirely on the FAC's effort to dismantle point by point the insinuations in the November 2023 17-point list, as well as the FAC's tired narrative that Miss Lively fabricated, materially mischaracterized, or grossly exaggerated all of the allegations she made in her CRD complaint and federal lawsuit.
Hey, hold on. Wait a minute. They restated them, her allegations, word for word, as they were stated in her CRD complaint. It's not our fault. Well, it's not Friedman's fault that her allegations are stupid. Literally word for word. You know, the claim is that she has embellished her SH claims, her SH allegations, to fit some narrative, and she was doing it in retaliation because whatever, she's trying to take control of the film. Our friend Anita would say that she was doing it prophylactically because she knew that Baldoni was onto her game, and they were prepping a conspiracy, business tort type of complaints, defamation type of complaint against her because of what she was doing way back when. And so she says, you know what? I'm going to just file a CRD here in California. They were advised to do it in California because 47.1 is a thing. 47.1 gives them kind of an insurance policy that if you want to hit us with a defamation suit and you lose, there's going to be treble damages and all this other stuff, punitive damage and whatnot. It would be really costly. Not that they think they're going to lose, but the risk of losing is a lot greater. It makes people real nervous if they want to go to trial.
Yeah.
Now, to Friedman's credit, he has resisted every urge to lean into a settlement on this case. He's offered no indication whatsoever that he plans on settling this case. He's going for their throats. And so Friedman he's litigating this case as if he's got the upper hand. The Reynolds and Lively parties are litigating as if they know they got a losing case. And they're trying everything they can in their power to overwhelm the Wayfarer party's side with paperwork, discovery, not agreeing to extensions. They're trying to put the pressure on so that they will them into a settlement of some sorts. I'm willing to bet, I would bet my house on it, that they will be the first one to crack and submit the first settlement offer. Now, you're never going to know about it because those things are confidential.
Right.
But they're going to be the ones to approach them and say, hey, if you drop your shit, we'll drop ours. And Friedman's going to get the fuck out of here with all of that.
Yeah.
It's exactly how it's going to go down.
I mean, Friedman did come out and say, like, they weren't just going to settle because, obviously, like, he needs his name cleared.
I mean, I never really buy when people say that because, look, there's always a settlement to be had. There's always. If they offer him $400 million, they will settle with an apology. We will offer Justin Baldoni a written apology and give him $400 million. Of course they're going to settle for that. There's always a way to settle cases.
Yeah, but that was the stipulation, though. There has to be like an apology or some sort of
whatever it is. Everybody's got their terms, their do or die terms. But the point is, you never go into litigation talking settlement if you want to appear strong and have the upper hand. Because
do you go into it like bitchy and childish, like the letter we just read?
No, you go into it exactly how these parties have gone. Like everybody claims that the other side is stupid and doesn't understand the law. Both sides are saying that. Both sides are being unreasonable. Both sides have not lodged any cause of action in their complaint. Both sides are, this is how they're doing it. Yeah. And they're doing that because they're posturing. That's all it is. The reality of it is, objectively, the law seems to fit Baldoni's complaint better than Reynolds and Lively's.
Mm-hmm.
So far, am I saying that they have a slam dunk case? Not by a long shot. I'm just saying that in the legal arguments that I've seen being played out so far, and these 12B6 motions are really hard to win. Mm-hmm. And so maybe my objectivity is a little bit skewed because I've been reading motions where the law favors the other side.
Yeah.
But it feels like Lively and Reynolds have the harder case. And so there's that. But not only that, just the pieces of evidence where you have, look, it's not just, I don't want people to mistake malice with ill will. Just because Reynolds says he doesn't like Baldoni doesn't mean that there's malicious intent. Mm-hmm. But if the motive was to push him out of the film because they wanted to start this franchise with It Ends With Us, and they use this conspiracy to get him out of the film, and it's attached to that specific motive, if a jury believes it, that's how you prove motive. Like, I don't have to like you. You know, if I don't like you and I say bad things about you, that's not defamation. That's not me having malicious intent. I just don't like you. Mm-hmm. But if I'm saying these things to get you out of the way so I can take your spot, that's malice.
Yeah.
Now, there's a lot easier picture to paint for Baldoni's side than Lively's side, because I feel like in a lot of ways, Lively has placed her stake in Jed Wallace. Jed Wallace is responsible for coordinating the smear campaign. It's like, Jed Wallace is like, what the fuck? I just went down there
last night.
I didn't know. I read that one, and what he basically said is, I don't know how I'm the conspiracy. If I'm a conspirator, then tell me all about it. I don't know. She hasn't pledged. She hasn't said who's involved in the conspiracy. She hasn't said what the conspiracy was about, who, what, when, where, why, how, any of this. And if there was, I didn't know about it. All I did was monitor the social media, and I told people to do nothing. What are we doing? Literally what he said. And if Wallace gets removed from the lawsuit, it's a lot harder for her then to prove a conspiracy, because then who was orchestrating? Who was orchestrating this big conspiracy against Blake Lively to smear her good name? Mm-hmm. Because from what I've read, she doesn't really have that great of a name. People have observed her as being a bully for years. Yeah. I know nothing about Blake Lively, but everything that I've read about these two competing parties is Baldoni's been this guy, and people make fun of him because he claims to be a male feminist, and he's standing up for women's rights and DV, and people will make fun of people like that because people are dicks. Blake Lively has a history of trying to bully people out of position, and so she can secure her own spot in an industry that's paying her tens, if not hundreds of millions of dollars. So it's not that far-fetched when she's giving interviews in 2019 talking about, oh, It Ends With Us, it could be this franchise. She has visions about, oh, it's not just going to be this movie. It's going to be like part 2, 3, 4, 5. It's going to become her Marvel Comics, Deadpool, whatever her husband has going on. And she's going to be able to retire off of this shit. She has reason and motive and the methodology to get Baldoni out of the lawsuit or out of the movie. And so she prophylactically filed this SH lawsuit because she's trying to push him out. And now that's why we're here. I know it's a big convoluted look. All I'm saying is it's a lot easier to see the vision of Baldoni's lawsuit than Lively's lawsuit in light of the evidence that's been presented so far. That's in no way stating that Lively still can't win this lawsuit. I'm just saying that for what's known from the initial complaints, the amended complaints, to these 12B6 motions, to the way they're litigating, it just looks like Friedman and Baldoni and the parties have the upper hand. That's all. Sorry for my rants. You can continue.
Yeah, that's why we're here, dude. You're fine. No. All right. I mean, don't go on a rant about like protein shakes or something, but this is fine.
Why in the fuck would I ever? Although Fairlife is the never mind. That's my protein choice.
We're gonna okay, so we're not gonna read this word for word because I did that earlier. So let's see. So this
just show me the interesting parts.
Yeah, it's like I don't know what you're interested in, but moreover,
well, I'll tell you what specifically. So she said at one point, the Wayfarer parties have tied themselves in knots. She said that they have admitted that they're. Oh, we talked about the $400 million lawsuit as a PR stunt.
Yes, we did. That was the first, right there. We just read that last part.
Okay,
that was the last thing we read.
She made a statement saying that they're unable to identify any actionable statements by Ms. Lively. They argue she is liable for things her husband allegedly said because Reynolds is an agent of hers, dipshits.
Oh, that's right. Well, they were saying like in the year 2025, here it is. In 2025, wives are not responsible for their husband's words. It's incredible that Baldoni, a person who calls himself a feminist, would take such a position.
Okay, that's true. No, she's right. She's right. Unless Ryan Reynolds is found to be an agent of Blake Lively and operating at her direction, in which case she would be liable for the statements of Ryan Reynolds. That's why if Ryan Reynolds' defamatory statements about the sexual predator stuff was for the explicit purpose and the direction of Blake Lively, now he becomes her agent. And she would be liable for those defamatory statements. It would defeat her 47.1 protections if a jury believes that that's what happened.
So you're thinking of like court stuff. I'm thinking of just like normal person reading this who doesn't really care about legal stuff. And I'm thinking like reading that, right? Because that's most people, let's be honest. So like reading that, I'm thinking like, yeah, okay, maybe a woman, of course, in 2025 is not on a standalone basis, like responsible for her husband's words. But if she lies about being sexually harassed and then relays that story to him, and then he runs off his leash and, you know, goes and bites someone, it's kind of your fault. Yeah. I mean, you're the one who told him the story that made him mad.
It's a lot simpler. This is the simplest terms you could possibly put it. If your husband hauls off and kills somebody without your knowledge, that's not your fault, right? But if you told him to do it, that makes you like an accomplice. That makes you responsible because he's acting in your direction.
Right.
That's literally the Charles Manson case from the 60s. And so the argument here is not, it has nothing to do. Look, of course, husbands and wives are separate. But if she's acting at her direction and is part of this conspiracy to get him off of the movie, to literally the benefit of him and his wife, then he's culpable. And that's the agency argument that I'm talking about. I know that it's not just for court, it's for regular folks. That's literally what's happening. Think of it in terms of wife hires husband. Well, wife tells husband to kill her ex. Who's guilty of the crime? They're both guilty for different things.
Yeah. Well,
and matter of fact, she would be guilty of felony murder because she's committed a felony that led to a death.
It's not just conspiracy or whatever. I mean,
no, it's simpler than that. It's felony murder. It's just straight up murder.
All right, cool.
Anyway, Lauren, you pretend like you don't understand this shit. I happen to know that you scored a 163 on your LSAT, and so there's no way.
Bro. It was a 162, and it was a long time ago.
Wow.
So yeah, basically it didn't happen. Okay. So like I said, we're not going to read this word for word, but let's get into this. Let's see. Realizing that a loss of the defamation claim subjects them to attorney's fees, treble damages, and punitive damages under 47.1. They attack that provision on constitutional grounds, which is an attack on all victims of sexual harassment and assault. Fortunately,
that's what got you so upset earlier, isn't it?
What's that?
Is that what got you so upset earlier?
Yeah, I was pretty pissed.
Yeah.
Yeah, I'm about tired of seeing that. I think it's crap. And even if you just like lied a little bit, even if like what she said happened, you know, like even if some of that did happen, it's like when you lied about all this other stuff and left this context out intentionally, and then you keep playing this all victims card, it's like don't attach other people to that. No, you lied, own that, you know, and then if it comes out that they actually did something wrong, then I'm sure everyone will treat that appropriately, you know. But like, I don't know, it bothers me that they would intentionally lie and leave things out and like have all that exposed in a widespread in the press, and then like to keep enacting this all victims narrative as if they speak for anyone other than themselves is ridiculous. I know, I get it. It's like a legal filing, but like just from a personal perspective, just like a layperson perspective, fuck that.
Well, look, there is an awakening that's happening in this country. In case you've been living under a rock, there's a lot of things changing with this country. And this line, which is an attack on all victims of sexual harassment and assault, we're starting to redefine what that means. She's a victim of sexual harassment based on her 7 stated allegations in her SH complaint. That's what she's claiming makes her a victim. There's actual victims that have experienced horrific things, that have experienced actual harassment, that she's harming by trying to stretch SH into what she's alleging that Baldoni did. All of a sudden, sexual harassment is hiring your friend, who is a Shakespearean-trained actor, to play the doctor delivering your baby. That's what sexual harassment is. Sexual harassment is showing the afterbirth video from Jamie Heath for like a second on the set of a film or whatever.
One frame, yeah.
Yeah. Oh, I mean, we could go through that list. That's what we're calling sexual harassment?
Mm-hmm.
She's doing a lot more harm. I understand your fear. I understand why it makes you so upset, because she is doing a disservice and she is watering down the victim pool of genuine sexual harassment and assaults recipients who are actually victims, playing the victim here while living her Hollywood lifestyle, all the while she's benefiting from the riches that have been brought in by this movie. She's going to be just fine after this. Others do not have access to all of those riches, and they're just simply victims. And they don't have $100 million to spend on litigation to file this garbage that we're reading right now. Mm-hmm. And so I completely understand the anger from you coming from this filing.
Yeah. Well, you would think that maybe just reading through all that shit with Laura would be like, somewhat prepare me to deal with that kind of bullshit. But at the same time, it still just makes me just as angry, you know?
Well, Laura's a little bit different because I feel like she's mentally ill. I think that Blake Lively's just a sociopath.
Laura is a personality disordered individual, in my opinion. That is not a mental illness that excuses that behavior.
Well, you know better than I would. But when I view her, like I view her as if there's something wrong. I look at Blake Lively as just straight up a sociopath. Just doesn't give an F.
Yeah, seems that way.
Now, I have no reason to say that other than what I've seen in these pleadings. I've never watched a movie of hers. I've never watched It Ends With Us. I've never watched
she killed
anything.
A bunch of donuts. So, yeah, she's a sociopath. I would argue she's a murderer. All right. Let's see. So we got to the 47.1 here. Well, they're just briefly kind of skimming over it for a second. What is this? Okay, they attack that provision on constitutional grounds. Fortunately, the Wayfarer Party's effort to invalidate California's duly enacted legislation is frivolous. The First Amendment empowers legislatures to protect victims' First Amendment rights via fee-shifting rules designed to deter retaliatory litigation. And we kind of went through all that, I feel like, in the last one.
Well, it's the 47.1 protections that they're referring to.
I feel like that was like cut and paste. Like, I don't feel like they even tried to.
Yeah, a lot of the stuff is cut and paste. It really doesn't even apply. To some of these things.
Right. Okay, so let's go down here. The Wayfarer Party's desperate attempt to reframe the defamation claim fails to save it. I mean, we kind of just, that was in the beginning, we went over that. The opposition fails to show that Ms. Lively is independently liable for defamation for her own alleged statements. Let's see. They don't identify a specific defamatory statement made by Ms. Lively and ignore the Single Publication Act. Any thoughts on the Publication Act? I don't know what that is. Single Publication Act.
I missed where I totally zoned out. You're going to have to read that again for me, miss.
The bold right there. It says they failed to identify a specific defamatory statement. Yeah.
Made by Ms. Lively and ignore the Single Publication Act. This is what the publication protections or the journalist protections or litigation privilege. Is that what she's referring to?
I guess so. Let's see. Protections for return to collection, blah, blah, blah. Let's see if it's they mentioned it in here. I don't know.
It's right bottom paragraph. Right there. Moreover, the Single Publication Act bars any claim based on Ms. Lively's alleged statements relating to protections, no matter to whom or in what form she made them, because they were first published before January 17, 2024. I think they're going to argue statute of limitations. The FAC is explicit. As of 2023, Wayfarer found a stunning list of protections unsettling, believed it misrepresented set culture, attempted to revise it, and concluded that it had been drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. In fact, in arguing malice, the opposition identifies 8 bullet points that track the protections, Rather than confront the Single Publications Act, the Wayfarer parties ignore it. They did ignore it. I don't remember them talking about this. But basically what they're saying is that if this was the defamatory statement they're talking about, like her 17-point list or her whatever bullet points that was, where she was having a discussion with everybody about the protections that needed to be had on set, that happened back in December 2023. And by the way, if that's what it was, then statute of limitations, bitch, because in California law, you have a year to file whatever. And, their opposition was like, no, they didn't occur then. They occurred like later in January, well within the statute. I forgot why, what specific like event that they said, but they made an argument where the statute of limitations was going to be a thing. I don't remember what it is off the top of my head, though.
Gotcha. All right, let's see. The false and insidious story. Okay, so the allegation that before filing the CRD complaint, Ms. Lively told the Times a false story that the Wayfarer parties retaliated against her similarly fails. The Wayfarer parties do not identify any statements at all, much less statements either specific enough to enable Ms. Lively to defend herself or ones that are not wholly contained within the legal complaints and therefore privileged. Okay. I don't really know.
Yeah, it's getting late. I just spaced. When you were reading that, my mind went straight. I was at Disneyland when you were reading that sentence.
Disneyland's closed, dude.
I was thinking, I got to take my daughters there this weekend. I'm not looking forward to it. There's worse things to not look forward to. I'm just saying.
Yeah,
it's different when you're taking a 5 and a 6-year-old.
Pass.
I'm just trying to keep them alive. I'm not having a good time at all. I'm just trying to make sure that they make it home safe. That's literally all.
So they're talking about the fair report privilege, which I feel like we went over a lot.
Yeah, we don't rediscuss.
Yeah.
I will say that this is written a lot better than the other thing that I just read. What did I just read?
The letter or the something?
Ryan Reynolds' response.
That was bad. That was the other night.
They should not have they shouldn't even wrote that if that's what they were going to do. Yeah. This is better written than that one. I don't know if this is, it can't be Gottlieb that wrote this, is it? And look, I heard someone say, look, Gottlieb is a Harvard lawyer and he clerked for the Supreme Court. You shouldn't be talking shit about him. Just because he has those credentials doesn't make him, it's Ezra. She's a really good, it doesn't make him a good legal writer. I've known a lot of dumbasses that went to Harvard, believe it or not. Just do not be fooled by people's credentials. They will show you who they are in due time.
Okay, fair enough. Let's see. And I actually never heard any of that stuff about him. So I mean,
it's in my comments. People are making comments like, no, this is what the comment was. It was basically like, people keep shitting on Gottlieb's legal writings like he's doing something wrong. Am I missing something? He's doing something wrong? He is a Harvard-trained lawyer, and he clerked for the Supreme Court. And I'm like, well, that's because like 90% of the law, he got it wrong, and he was purposely misstating the FAC. Mm-hmm. So I just kind of called it how I saw it. I was calling balls and strikes. That's all. Just because you went to Harvard doesn't make you a brilliant legal writer. Some of those people are shitty at it. Just saying, man. It's just how it is.
Let's see. The Wayfarer party's baffling argument, that Miss Lively did not seriously consider litigation because she waited to file suit for 11 days after receiving the right to sue notice is meritless. So what are we thinking about that? Do you know? I mean, have you seen that part at all?
Yeah, they're claiming that Lively did not feel harassed. Mm-hmm. If she really felt harassed, given her conduct on the set, she would have filed this complaint right away. Instead, she waited 11 days. I forgot what the wait was for. And she did it basically prophylactically after catching wind that Baldoni was possibly gearing up for a lawsuit against her for some of her behavior towards him and trying to push him off the set.
Okay. Sorry, 1 second. I'm just fixing something real quick. Not that. That's not what I want. That's not what I want. Stop it.
Are you sporting a mohawk? What's up with your hair? Oh, it's
there's something behind me. What a mohawk, bro. That would not.
It looked funny on camera, is all.
Good. All right. Anyways.
Oh boy.
Okay. Let's keep scrolling here. We've been over the sexual harassment privilege, which in my opinion should only apply to people who are telling the truth about it. Let's see.
How would you enforce that, though?
I know.
Right.
Miss Lively is not liable for statements that she did not make. We went over that. It's about her husband and his statements. Her husband, as if Ryan Reynolds isn't his own famous person.
Mm-hmm.
My mind just goes, I don't even think Ryan Reynolds anymore. I just think Blake's husband. So.
I didn't really know much about Ryan Reynolds, but when I think of him, the image that comes to my mind is him in that Bob, is that what it's called? The man bun thing. The man bun thing.
Oh, yeah, from Deadpool.
That's the image of him that's in my brain whenever I think of Ryan Reynolds.
Okay. Let's see. I
got all this energy off, so I gotta go to the gym or something, do some push-ups.
Dude, it's like it's midnight 30 here. And
no, man, I'm training. I'm in training. Oh, I'm not losing.
All right.
I'm not losing, man. I'm just saying.
We'll see about that. The Wayfarer party still failed to plead the basic elements of extortion. First, they cite an unknown executive's comments that Miss Lively allegedly demanded an apology from Wayfarer, Heath, and Baldoni, or the gloves would come off. They don't explain how this amounts to a wrongful threat, nor can they.
Read that again?
Yeah. So they're complaining that first they cited an unknown executive. So I don't know which executive that was. I can't remember which one. That Miss Lively allegedly demanded an apology from them, or the gloves would come off. So
that's not alleged. Wasn't that that's well documented. It's not alleged. That happened. Or the gloves would come off.
I'm just reading the page, man.
Okay.
Yeah.
Okay. They don't explain how this amounts to a wrongful threat. What do you mean they don't explain? I can't even. I've been sapped of energy all of a sudden. I was all energetic before, like 5 seconds ago, and that just took it right out of me. I can't.
Well, if only the Harvard Supreme Court man, whatever, had written this one, maybe you'd be awake still.
This is better than Gottlieb's writing.
Is it?
I can only assume. Well, Gottlieb wrote Reynolds' thing. His name was signed on it.
Well, you said his paralegal or whoever probably wrote it, and then he signed it.
I was giving him the benefit of the doubt, but what if he really wrote it? I don't know.
I don't know either. All right. Let's see. That's worse yet. The Wayfarer parties concede that Miss Lively did not acquire money or property through her purported wrongful threats.
Yeah, once again, that's not required. There's cases that state that just because money didn't change hands doesn't mean that you didn't extort for valuable things. Mm-hmm. Producer rights, ownership of things, future movie roles, and whatnot.
The Wayfarer parties, and this is a footnote, the Wayfarer parties do not address cases cited in the Lively motion establishing that extortion requires 1, wrongful acts, and 2, the deprivation and acquisition of property. Okay.
I think they did address it. This element is not contained in the cases that she cited. This is boilerplate language that are the elements of proving that idea, what extortion requires. Wrongful acts and the deprivation or acquisition of property. To the extent that property rights to a film would be construed as property, I think they've satisfied the elements.
Yeah. Okay.
And so it's a moot point.
All right. Let's see.
Laura's like, huh. I feel like I know when you zone out. I'm getting used to your noises.
I did hear what you said. It just took me a second to process it. Okay. Remember, we take turns paying attention here. All right. The Wayfarer party's admissions doom the breach of covenant claim. All right. What is that exactly?
Wait, what did you ask me?
The breach of covenant claim. What is that?
I don't fucking know. What is that?
I'm asking you.
I literally don't. I don't remember what that is. The breach of covenant claim.
Recognizing the fatal.
Or some breach of contract.
Breach of covenant. Maybe I don't know. Hang on. Let me see.
Let me read this. Recognizing the fatal defects of their breach of covenant claim, the Wayfarer parties resort to asking the court to consider the new facts in their opposition that Miss Lively contract granted her the right to consult and approve on certain aspects of the film's production and marketing. They're talking about the business torts and to terminate her performance under extremely narrow and inapplicable circumstances. But a complaint cannot be amended by the briefs in opposition to a motion to dismiss. Even these new allegations fail to support the claim. Miss Lively was contractually entitled to participate in the film's production. No specific contractual provision was frustrated. No damages are alleged. No parties to the contract are identified. These defects doom the implied covenant claim. Well, implied covenants is literally, we don't have a written contract, so we have to imply a contract. How do you imply a contract? By the actions of the parties. So, like I've been saying over and over again, somebody got these parties together to go make a movie. There was an understanding of hierarchy. There was an understanding that there was going to be producers and filmmakers and camera crew and extras and all these things. They cast roles. Blake Lively was playing that role for a reason. Baldoni was in that role for a reason. And everybody else had these bit parts. Let's just say that nobody signed any contracts. Well, they got together and they made a movie for what? Well, she got paid. She got paid a certain amount of money. So we can imply that there was an agreement. There was a promise that if she played the role of that lady, and it ends with us, she would be paid a certain amount of money. Great. Now, that's the easy part. What about all the rest of it? That speaks to nudity writers, that speaks to protections for on set. It speaks to production schedules, wardrobe budgets, where they're going to shoot the scenes of location, editing rights, marketing plans. All of these things happened, regardless of whether or not there is a signed contract that lays it out. All of these things happened. And so where you don't have a written enforceable contract of the parties, you could construct one by the behavior of everybody involved. And so I've never liked this argument from them. They've been saying this like from the very beginning. It's not impressive to me then. It's not impressive to me now. When they say that there's no contract, you literally made a movie. So something happened. There were promises made and promises kept. And some promises weren't made and some promises weren't kept. And what those little minor provisions are going to be are issues for the jury to cipher out. So how about that?
So, you know, I didn't know about that letter until the stream started. Like they just put that in.
Yes.
The 4-page letter that we spent half an hour on. Do you remember before the stream started when I said that nighttime gummy is going to kick in about an hour?
That's why I felt like I was talking to myself. It's like, Lauren is not listening.
You lost me like 5
I am talking to the public right now.
So we weren't supposed to be going for this long. I didn't know that was going to happen. And now I'm kind of effed.
You're good. I got this, Lauren. I got this. I got it.
Okay,
I'm not offended.
Wait, okay. We have so this is probably the last claim, and I think we're at the end.
All right, let's do it.
Read? Because I can't read.
I will take over. I got this, Lauren. Let's do it. All right. Each tortious interference claim must be dismissed. First, the Wayfarer parties do not identify a specific contract with WME. That is a stupid argument for all the reasons that I just said when Lauren was spacing out. Speculating instead that Miss Lively, as a WME client, has knowledge of such a contract. She did. She showed up for work. She showed up for film schedules. She had specific requests to change things that were obviously agreed to. And so she was aware that she was under a contract. She accepted money in return for her services. So that, however, fails to meet the Wayfarer party's obligation to plead a specific contract and its term. I will agree with them on this, though. We still don't know the specific terms of the contract because they have not been pled out. And I think that's going to be probably a subject that Judge Lyman asked them to amend. I want to know what the specific contracts you guys are saying were breached. Right now, I don't have the terms. I don't have signed contracts. I don't have anything. I'm going to need you guys to spell it out for me. I could see Judge Lyman saying that. The Wayfarer parties are also silent on their failure to allege if, how, or when.
Bugaboo!
My God.
Sorry, keep reading.
You all right, Lauren? Hey, let me continue. I'm not even on a gummy, man. You got me giggling over here. Wayfarer parties are also silent on their failure to allege if, how, or when Miss Lively interfered with the phantom contract. Of course, I can't even give legal analysis when you're like that. Oh boy.
Whoa.
They turn to the conclusion that she is somehow responsible for Mr. Reynolds' comments. Page. Oh my God. And thereby fail the pleading standard. Second, there's only 3 more pages. The Wayfarer parties admit that defamation is disguised beneath their economic relationship claim, but neither Miss Lively's, Mr. Reynolds, nor the Sloan parties' statements are actionable. Oh, Lauren is on a good one, man. I don't know what she's on, but she's on something.
I had one gummy. It was like a $5 milligram. It wasn't even that.
Maybe next time take half.
Maybe.
Neither Miss Lively, Mr. Reynolds, nor the Sloan party statements are actionable. Then aside, the FAC does not. This is not Ask Two Lawyers level of. Imagine those 2 fucking guys like on a gummy doing their thing.
That would be amazing.
Oh, that would be the show to watch, man. I would sign up for that one in advance. Oh, if someday me and them ever collaborate, I'm going to make sure they at least have a glass of whiskey. It'll be on me. The drink's on me. All right. The FAC does not allege how these purported statements disrupted the W&E relationship, and a central element of the claim. They're buried in a footnote. The Wayfarer parties. Can we just skip over this shit? Nobody gives a shit about the business stores.
Okay.
Look, here's the spoiler alert. The judge is going to ask them to amend their complaint to better describe what the contracts were. That's what's going to happen. Anyway, skip down to number 2. The Wayfarer parties' attacks on 47-1 fail. I'm actually interested in this part. All right, I'm going to try to be serious.
Me too.
Let's do it. All right. After years of promoting themselves as supporters of women and victims of abuse, Baldoni, Sarowitz, and Heath attacked a California statute that was drafted specifically to protect victims from abusers who weaponize defamation law. Contrary to their self-serving contention, Section 47.1 is not a procedural statute. It's a substantive privilege against liability with a fee-shifting and damages provision attached, both textbook examples of substantive California law that applies in federal diversity actions. They cite an unpublished case.
Okay, David Gingras.
I'm just saying they did. This is an unpublished case. What the fuck? What are we doing? Page. That provisions, holding that provisions for attorney fees are a substantive, not procedural right. Fine. Oh, Jesus. All right. The Wayfarer parties nor Pennington challenges likewise without merit. A court in that district rejected a similar challenge, noting the Supreme Court's caution that the pre-standard is a doctrine of antitrust law and that it's holding a firmly grounded in the text. I could literally be saying anything and sound like I'm reading. Lauren has bugs in her hair.
Michelle's
spiders all over her arm. Climbing up.
We amend again, it'll be called a sack.
It's called a hairy sack. The first amended hairy sack alleges.
Oh, funny, you just try shaving first. God.
Manscaped 2.0 lawnmower. It comes with a toner. All right.
We're almost there, guys.
I don't even know what I'm reading right now. I'm just.
Me neither.
Jesus Christ. They're talking about antitrust law. This is all bullshit. Can we just call it bull? Can we scroll down a little bit? All right, as an Adelson, this admonition against Jesus. All right, let's start here. If Nora Pennington bars 47-1 treble damages, I don't think it does, to be honest with you. I think that they're right on this one. Such a bar would not preclude the independent fee shifting remedy. Nora Pennington does not apply to fee shifting provisions, considering California's presumption of severability in the history and purpose of legislation. It is evident the California legislature would have enacted fee shifting. Look, I think the 47-1 damage provision, fee shifting provision, is going to stick. And it's going to be significant because it's going to give Baldoni some incentive to want to settle. Because if he loses on the defamation claims, it entitles her to all kinds of nasty things, punitive damages, treble damages, and whatnot. Anyway, that's actually a meritorious argument that I think that they're making right there. The rest of it is garbage. The end result is exactly what we've been saying. None of these motions are going to get granted, save for maybe Wallace's. And I think that there's going to be, obviously, another leave to amend that the Wayfarer party is going to have to do, and they're going to do that. And it's going to happen sometime at the end of this month. How about that?
Okay, I'll hold you to that.
All right. Every time I've made a prediction, every single time, from all the months that you've known me, I've been exact. I've been right on every single thing. I can't recall a time where I was wrong.
I can't recall a time 5 minutes ago, so I don't know.
Well.
That hits so
Are we mercifully done with this shit?
Yeah, that's it, man. I mean, this was the last page, I think. Yep, there we go.
All right.
All right. Well, thanks everyone for sitting through that. I'm going to read these super chats, or attempt to, before we go. Hang on. I got to go fast because if I don't, then I'll start giggling again. And Nolan Uzi, thank you for the $10. I can't wait to hear what he has to say. I would also like to see him bounce ideas off the two lawyers. Oh, yeah, I guess you should go hang out with those guys.
I totally would. You
not like tonight, but
not tonight. That'd be weird. But I think they're probably busy. They haven't posted in a while.
Yeah, I guess so. Somebody said something. Do you think they got a cease and desist? I was like, no, I don't think they got a cease and desist.
I just know that I tried once to throw people from my stream to their stream. And it's like, you need permission from Ask Two Lawyers to refer people. It's like, well, fuck you then. How about that?
You have to get the principal to sign this letter first.
But they did invite me to lunch once because they're literally 15 minutes from my office. I've never reached out to make that happen, but maybe I will.
Oh, it's still standing. Okay, I gotcha.
Yeah.
Tina, thank you for the $20 just donating to the cause. Omar, this one is for you if you want to read it.
Oh, thanks for down. She said, let's do this. This thing is done.
Which part?
This thing is done and then some. Lauren is done. She's done with something.
Lauren's exhausted now. Brent W, thank you for the $5 to help supplement ad replacement fund. Thank you, Brandon. Thank you. Oh my God, that feels like 3 hours ago. Oh my God. Michelle Moulton, thank you for the CA Canadian. What's the Canadian currency called? I don't know. It's 14 though. Thank you for.
It's called the Mountie. It's called the Mountie, Lauren.
Are you lying to me?
Whenever you hear Canadian currency, I want you to call it the Mountie.
I'm scared. Michelle, we're going to talk about this later. Message me what I'm supposed to call that.
Totally believe everything that I'm saying.
Absolutely, every single time. Rihanna Vasconcelos, thank you for the 1090 super sticker. I appreciate it. Let's see. Just Ricardo, thank you for the $2. Every accusation is an admission with these people. That seems to be true, doesn't it? Amy Anderson, thank you for the $50 super sticker. I appreciate you. Let's see. Mona Lisa Mohidin, thank you for the $20 Mounties or whatever. Super sticker. Thank you. This is for you, Omar. You want to read that one?
Oh, do Ryan Reynolds have a share in Blake Lively Company? She signed contract with just. Why does that look like fish in a bowl? Do Ryan Reynolds have a share in BL Company? No, it's the green. I don't know. She signed contract with It's the initials. Does Ryan Reynolds have a share in Blake Lively's company? She signed contract with JB. Who's JB? Oh, Justin Baldoni. No, I don't think that Reynolds has a share. I think he's an employee.
Oh, is he?
Of her, I think so. Either way, if he has a share of her company, it makes him an agent. If he's an employee of her company, it makes him an agent. If he was a contractor to her country for a specific purpose, it makes him an agent of Blake Lively, which makes his statements that he made against Baldoni that may have been maliciously defamatory. It makes her liable for those statements, which may defeat 47.1. I think that's what we're getting at. Okay. This is too much for Lauren right now. She's
I can click the buttons. We're good.
She's on Pluto.
Claude Simba, thank you for the $10 super sticker. Appreciate you. You got another one, Omar.
Oh, Omar and Lauren, I needed that laugh. This is from Aquanetta. How you doing? I've seen her in a while. She's always in my streams. She missed the last one or two, or maybe it's just me. My memory is. It's Thursday night, man. I'm ready for the weekend. I really am. It's been a long week.
Okay. Let's see. Brandon W, thank you for the $5. I think Omar is very near from where I'm from. I'm from Simi Valley. What's Simi Valley?
Simi Valley is not too far. I don't know how far that is from me. Let me see. I'm going to Google map it right now. Google Maps. I'm coming to your house. I'm not.
Whoa. Escalated so quickly. High Life, thank you for the $2. I like your name. Love to you both for reading the BS. Thank you very much for still wanting to be here after the last, I don't know how long, 4 hours since the gummy hit me. Seriously, I have no idea.
Yeah, I'm like an hour 20 minutes outside of Simi Valley.
Oh, okay.
Bruce says that Omar and names aren't on a first name basis. No, we're not. I call Bruce Brad all the time, and Brad Bruce. And
you call me Laura.
Like, seriously, Omar, JB, you don't know? Yes, I know who JB is, but when you put it like that, sometimes it takes me a minute to readjust. That's all.
It's been 5 minutes, Lauren. It's been at least 15, okay? Jesus. No, it hasn't not. Has it actually been 10 minutes?
10 minutes since the go. It's been about 10. It's been about.
You're fucking kidding me. There's no way.
No.
It's been like at least half an hour. What are you talking about?
Your eyes glazed over. I saw it happen. I was like, oh, I'm losing Lauren. What the fuck is happening? And then you were like, you know what? Remember I told you about that gum I took an hour ago? Well, it hits.
Well, if you take off the 30 minutes that we spent on the stupid ass letter, then you get to like we're done right before I hit that point. So I thought I timed it perfectly, and then they fucked me with their 4 pages of semen nonsense. Okay, I don't know.
It was semen nonsense, by the way.
Why would you say that?
I don't know. Why did you say that?
I didn't say that.
I know nothing about semen other than it. Never mind.
Whoa.
I have semen and you don't. That's all I'm getting at.
That's not true. I was a straight person in college once. I had. Never mind. It was a loan.
You're not allowed to identify as having semen. Is all I'm saying.
It's time to end. Okay. Good night, everyone. I'll see you tomorrow. Bye.
All right, folks. Have a good one. We love you all.